Can my wife register our child in my absence if we are married under religious law? The short answer: a mother can register the child in the father's name if she has proof of marriage. The whole question: can my wife still register our coming baby's birth under my name in my absence, given that we were married under religious law, or do we need to follow other procedures? The long answer: in terms of the Births and Deaths Registration Act, 1992, the births of all children born in South Africa must be registered within 30 days of their birth. That registration must be done by the parent or parents, guardian, or any other person legally responsible for the child. I can see no reason why your wife would not be able to register the baby's birth under your surname, as you are married. But in the absence of a marriage certificate, she would have to provide other proof of your marriage. This may be what you mean by following procedures. You may be aware that the Constitutional Court finally confirmed in June 2022 in Women's Legal Center Trust v. President and others that the non-recognition of religious or Muslim marriages under Sharia law was unconstitutional. This was because it denied Muslim women and children their constitutional rights to dignity, equality, and the best interests of children. Women in civil or customary marriages enjoyed rights of access to courts in terms of the Marriage Act of 1961 and the Divorce Act of 1979, according to which Muslim women were denied because these acts did not recognize marriages under Sharia law as valid civil marriages. In the case of a divorce in which children born in civil or customary marriages are involved, the courts assume an automatic judicial oversight role and are obliged to take into account the best interests of the child. This is not the case for children born of Muslim marriages, who are not provided with the same automatic court supervision. Thus, the court found that the non-recognition of Muslim marriages infringes on the best interests of the child. The Constitutional Court gave Parliament 24 months to amend the laws or introduce new legislation to recognize Muslim marriages, and in the meantime, all Muslim marriages would be regarded as being out of community of property and without accrual. However, in the 24 months before the legislation was amended, women in a religious marriage could access any of the rights in the Marriage Act and the Divorce Act. Mondak points out that the common law definition of marriage was also declared to be inconsistent with the Constitution and invalid because it excluded Muslim marriages. The common law definition of marriage now includes Muslim marriages. Muslim marriages are therefore deemed to be valid and legitimate. The Western Cape government website says that if you are married, the child will be registered under the father. Home Affairs refuses to give us permanent residency even though we were born in South Africa, and our parents and siblings have permanent residency. What can we do? The short answer: as you were both born in South Africa before 2014, you still automatically qualify for citizenship provided you have not lived anywhere else but South Africa. The whole question: how can we get the documents we need to be accepted as South African citizens? My sister and I were born here and are both adults, but we do not have birth certificates with ID numbers. Our parents and 2 older siblings have permanent residency and non-citizen IDs. The long answer: the South African Citizenship Act of 1995 was amended in 2010, and the amended version came into operation on 1 January 2013. It means that children of permanent residents born after October 2014 no longer qualify for automatic citizenship or permanent residency. It means that children born after October 2014 will need a visa from Home Affairs before applying for citizenship after they are 18 years old and have lived here all their lives. As you were both born in South Africa before 2014, you still automatically qualify for citizenship provided you have not lived anywhere else but South Africa, and if your birth has been registered under the Births and Deaths Registration Act of 1992. This is in terms of the amended Citizenship Act. But if your birth was not registered under the Births and Deaths Registration Act, and thus you have no birth certificates with IDs, do you have proof that you were born here, like clinic cards or statements from a hospital? Your parents could make affidavits confirming where and when you were born in South Africa. You would need to take this evidence and submit it to Home Affairs to apply for birth certificates under a late registration of birth. Even though you were both born before 2014 and so automatically qualify, you still need the birth certificates. As you are both older than 15 years old, you would also need to provide the following documents to Home Affairs, DHA. Completed forms for the registration of birth. Supporting documentation like proof of birth, or clinic card, as well as written reasons why the birth was not registered within 30 days of birth. Certified copies of parents' non-citizen IDs. The Department of Home Affairs, DHA, does have a specific hotline for inquiries about birth certificates and also a dedicated email address. But as you have already experienced difficulties with Home Affairs in obtaining the documentation you need, perhaps you should consult one of the organizations that have had a great deal of experience in dealing with Home Affairs.